this time.
I just wanted to let you know that I didn't get the whole 2,500 in, but
See that.
1,000. I will have the rest of that next Friday to turn in. I also would like to countersue just because I came here. I'm still not peacefully.
Okay. Mr. West, I'd appreciate you not smoking.
Yeah, no, I'm not.
Okay. All right. Mr. Getz?
Yes, Your Honor.
What is your claim in this case?
So he hasn't been paying rent for the last 2 months. We're approaching a third month without him paying rent. I tried to serve a notice to vacate on the first month and I didn't use the right paperwork. So I served a 7-day notice to quit.
Okay. So, sir, how much does he owe?
At this current moment, $1,400.
All right. Then you've got costs, it looks like here, about 87. All right. Sir? Mr. West?
Yes. Yeah.
How are you intending on getting this paid?
Well, what happened was when I moved here, I didn't have any money. And I've known this guy since like first grade. He told me it was cool. And I got 2 jobs and I started paying the rent. And the rent wasn't, there was never any lease signed or anything. I never got, but the deal was that when I started working, I didn't have, it was like, I'll give you the money when I get paid. And in January, I paid him on the 23rd. And then in February, he got all drunk and started freaking out and told me he was going to throw all my stuff out and started putting my stuff in boxes and throwing my food away. That's why I didn't pay the rent. And I would have moved out if I had anywhere else to go. But
All right.
I don't have anywhere else to go. So
this is a non-payment case, so do you have the money to pay?
No, not now. I don't.
Okay.
Yeah. I moved in here and this guy told me he was on felony probation and he wasn't drinking. And then he's drunk every day going crazy. And I ended up getting fired because I didn't sleep for a week dealing with this. Like it wasn't like I just didn't pay the rent. Like I'm trying to get it together and get out of here.
Do. Second service wasn't paid for. What I'm going to suggest.
I don't know what that means. I don't know what that means.
There's not a second service by the court, which means I can't take a default or do anything today. I'm going to adjourn this out. Mr. West, if you think that you need an attorney, and for that matter, Mr. Guess, if you think you need an attorney, that'd be your opportunity to hire an attorney. We'll adjourn this out to April 10th, 2026 at 2 p.m. That's an in-person hearing. I'll need you both down here at the courthouse. All right.
You said April 10th?
Mr. West, April 10th, 2 p.m. Mr. West, okay. In the interim, what I'd suggest you do is accumulate what funds you can when you come down, because I think Mr. Getz is probably correct. Another month is going to click in by the time you get back here. And so there's going to need to at least be a payment while you guys try to work this out. All right?
I would pay it if I had the money. I don't have the money. It's not that I wouldn't pay it. I've been trying to find a job.
I hear you. What I'm indicating, though, is that you said you had jobs.
Not anymore. Not anymore.
Because you got fired.
Yeah.
Okay. Well. Okay. So we'll see you guys down here April 10th, 2 p.m.
Thank you, Your Honor.
Okay.
All right.
Do I have to do anything else right now, or?
Well, if you want to hire an attorney, you can, or if you want to seek assistance, you can call the numbers that were on the slideshow at the very beginning. You can call Hawk. Did you get that number?
No.
All right. Got something? Do you have something to write with?
Hold on one second. I do. Okay.
That's area code 734.
734.
Yes, sir.
And what was it called again?
It's called HAWC. That's an acronym. It's HAWC. Housing Access for Washtenaw County.
Okay, and you said April 10th at 2 p.m.?
Yes, sir. In person.
What, is that just Saline Courthouse, or like to get directions?
You're gonna come to the courthouse I'm at, which is the one by the sheriff's department.
What sheriff's department? In Saline?
Washtenaw.
Or?
No. All right.
I just moved here in October. I'm not from, I don't know
Okay,
where any.
no, I got you. I'm just trying to explain it to you.
Yeah. I'm not trying to
No,
give you a hard time.
Sir, I'm just trying to tell you how to get here.
Okay.
The address is 4133 Washtenaw Avenue.
Okay.
Okay, and it's right off of US 23.
Okay.
All right. So if you were to just ask or put in your phone the Washtenaw County Sheriff's Department, it'll show you this location. We're right attached with them.
Okay. Well, if I don't get some money, my phone's gonna get turned off. Can I still show up and do this without my phone?
Oh yeah, you can show
Okay.
up.
Okay.
I was just saying, use your phone to find the location.
Yeah. Yeah.
Okay.
Okay. Yeah.
All right. We'll see you. Yep. Hang up.
Okay. Okay.
You're
Thank
good.
you.
All right. Okay. Court's in recess. Court does call the case. People versus Latanya Lang. Just an arraignment.
Your Honor, Kristen Lewis Perez requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Chief Assistant Prosecuting Attorney Victoria Burton Harris.
Actually going to let you do things.
Mm-hmm.
Okay. All right. Permission to practice is granted.
Wanted to see more of me, so we made it happen.
I did say that. So I'm glad. All right. Ms. Link?
Yes.
All right. Ms. Link, you are before the court on a felony complaint that alleges that on or about January 1st, 2026, at the location of 725 Manor in the city of Ypsilanti, Washtenaw County, state of Michigan, that you did make an assault upon a Kaylin Lowe by strangulation and or suffocation. Do you understand the nature of that charge, ma'am?
Yes.
All right. That's a felony punishable by up to 10 years, up to a $5,000 fine plus court costs. Do you understand that?
Yes.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes, I do.
All right. This is a public defender case.
Good afternoon, Your Honor. First Assistant Public Defender Queen Anderson. Your Honor, we met with Ms. Link this morning and she declined counsel, so we did not have an opportunity to speak with her. If Your Honor would allow Ms. Van Blarken to have a moment to speak with her in a breakout room, please.
You want me to give a breakout room?
Yes, please.
Have I ever done that? Fine, Anderson. You know she'd ask. I'm going to do that. All right, ma'am.
Yes.
Their attorneys came to speak with you earlier today, and you declined to talk to them.
Yes, I did. Yes. Yes, I did.
Okay, but you want to talk to them now.
Yes.
Okay, so what I'm going to do is we're going to put you into a breakout room and let you have an interview with them. Okay.
Okay. Okay. Thank
And
you.
then come back out and we'll finish.
Okay.
Please.
And we have Miss Link back. All right, Miss Link.
There you go.
All right. State your name again, please.
Latanya Link.
All right, you've had an opportunity to speak with the public defender?
Yes.
All right. As to the arraignment portion of this from the PD.
Yes, Your Honor. Thank you, Nicole Van Blarkum, with Washtenaw County Defender's Office on behalf of Miss Link.
All right, you're waiving formal reading and standing mute to the charges.
Yes, Your Honor, and we reserve the bond argument.
All right, defendant having waived formal reading, standing mute, court will enter a not guilty plea. In this matter, I'll set probable cause conference in this case for April 9, 2026, 9 a.m. From the people as to bond.
Your Honor, we are asking for a 25,000 PR bond. This occurrence is between a mother and the victim is the daughter. We are asking no contact with the victim. We still need to determine if the victim lives with her father. So we would ask that there is a no-go to wherever the victim currently resides. And then we'd like to ask for all standard bond conditions as well.
Response.
We have no argument to that, Your Honor. We would also ask for a personal recognizance bond. My client has no prior assaultive history, and she has stated that the daughter can go live with the father.
All right. So is the daughter currently at the manor address?
Yes.
Or do we? She's
Yes.
currently at that 725 manor?
Yes.
Okay.
And Your Honor, Ms. Link has stated to me that her daughter's father can come pick her up if she is to be released.
Okay. Well, there's a problem because if I order a no-go to there, and certainly I'll order the no contact in the interim time with Caitlin Lowe. But my concern is if I order the no contact or no go to the manor address, father comes and picks her up, defendant is still bound by my order because nobody's going to know.
Right.
Ms. Link,
Yes.
do you have some place that you can stay if I order you not to go to that address?
Well, that's my house. I have nowhere else to go. Because their dad was picking them up to get their hair done. He was coming to
I'm
get
sorry?
them up. Their dad was coming to pick her up to go get her hair done. So she was gonna stay with him anyway the weekend.
Counsel, any suggestions?
Your Honor, would it be possible to get the address for defendant's daughter's father so that we could do a no-go to that address so that she could return home to be able to stay there?
Yeah, I don't have a problem with that. I'm trying
I
to,
need the address.
I think what is going to occur is she's going to go stay with the daughter. What I'm concerned about though is if I order the 725, presuming the daughter cooperates and she goes to her dad's home, then there wouldn't be a problem ordering no go to that address. If everybody's following me. The problem is that if I put the 725, defendant can't go there until everybody can get all of that straightened out.
Understood, Your Honor. Give me just one moment, please.
Is this a felony? All right, here's what I'll do, because it's going to come to me anyway. So, this is Friday. All right, I'm going to set her bond at a $25,000 personal recognizance bond. I standard conditions, including no assault behavior, no possession of any weapons, ammunition, or anything fashioned to be a weapon. Ma'am, there should be no possession or consumption of any alcohol, recreational marijuana, or illegal drugs. I will order no contact with Caitlin Lowe. At this moment, I'm going to order you not to go to the 725 manor address. All right, you understand that, ma'am?
Okay.
Okay, Ma'am, do you understand what I'm ordering?
Yes.
You're not to go there without a civil standby. What I'm going to indicate, counsel, is, if you can accomplish it today, that's fine, or you can try to reach me via email. If the parties can agree, once the daughter has gone with the dad, I will sign an order allowing her to go back to that address and not go to the other address. Okay, so you just have to, if you get that to Ms. Weidling, then she'll make sure I can get it, and then I can get it back to the parties once we have all that established.
Okay.
Okay? So you understand what I'm doing, Miss
Yes.
Link?
Yes.
Okay, so don't go there until you have verification that there's an order that allows you to go there. All
Okay.
right? You just got to go hang out someplace. You just got to hang out until we get that order, okay?
Okay.
All right. Is there anything else, counsel?
Your Honor, may I go into a breakout room with Miss Link one more time so I could get that address from her?
Did Miss Anderson tell you I don't do breakout rooms? And now you're going to get two?
She did not, Your Honor.
Okay, fine. We'll put you into a breakout room.
Thank you, Your Honor.
Thank you, Honor.
Thank you.
Thank you, Honor.
Let's call the case of the people versus James Richmond. Need to unmute him.
Kristen Lewis Perez here for the people, Your Honor.
Thank you.
He's unmuted.
He's unmuted. Sir, what is your name?
James Richmond.
All right, Mr. Richmond. I have two. These are warrants, correct?
She has a new felony,
Yes, I.
and the other two, one is a bench warrant for a retrial, one is a bench warrant for a show cause.
Okay, gotcha. All right. Mr. Richmond, you've got three matters here before the court. You have a new felony case. That felony case is alleging that on or about March 21st, 2026, at the location of 3239 East Michigan Avenue, that count one alleges that you did commit the offense of assault with intent to murder. Do you understand the nature of that charge, sir?
Yes, sir.
That is a felony punishable by up to life or any number of years in prison. You understand that, sir?
Yes, sir.
Count two is the charge of assault to do great bodily harm less than murder by strangulation. You understand that charge, sir?
Yes, sir.
That's a felony punishable by up to 10 years, $5,000 fine plus court costs. Do you understand that?
Yes, sir.
Count three is the assault with a dangerous weapon, or commonly known as felonious assault. Do you understand that charge?
Yes, sir.
That's a felony punishable by up to 4 years incarceration, a $2,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
Charge of aggravated domestic violence, second or subsequent offense. Do you understand that charge, sir?
Yes, sir.
And that is a felony punishable by up to 5 years and or $5,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
First question I have for you is, do you want to be represented by an attorney?
Yes.
This is a public defender case.
Thank you, Your Honor. First Assistant Public Defender Kalina Anderson, with and on behalf of Mr. Richmond in all files, Your Honor, in the two new cases, we would waive any further reading. Reserve the bond argument.
All right. Defendant heavyweight for reading standing mute. Court will enter a not guilty plea. I will set probable cause on this matter for, this is the 9th or the 2nd. Say again. April 9th, 2026, 9 a.m. As the bond from the people.
Your Honor, we are asking for $750,000 on this matter. We wanted to ask if you took the testimony on this case and referred to the bond rec form. It sounds like you have all the cases in front of you. So we just want to note that there was a large gap in time with no activity following his plea of torture. Felony assault and unlawful imprisonment is due to prison sentence of approximately 12 years, and that was from December 2007 to 2022, which was a parole discharge. He went back to reoffending very quickly with a DV case in 2025, and the violent circumstances of this offense just from last week. Incarceration has not been a deterrent, and his current probation has not affected the behavior. Right now, the people see this as highly lethal and a huge community safety concern, Your Honor.
No. Response.
Thank you, Your Honor. There's nothing else holding Mr. Van Blarken in custody Mr. Richmond in custody at this time. He did give us good contact information. In reviewing the charging documents, we see the severity of the crimes. He's not trying to diminish that at all. He's just looking forward to meeting with counsel and proceeding on his day in court. He would ask the court for a personal bond. If the court is not so inclined, then he would just ask for a reasonable bond to ensure his appearance at the next court date, and he would ask for the next available PCC date.
Defendant's bond in this case will be set in the amount of $500,000 cash surety. Although the standard conditions, including no assaultive behavior or possession of any weapons, firearms, ammunition, or anything designed to be a weapon. There's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. I will also indicate that the defendant is to have no contact whatsoever with Lori Ray Williams. That is, do I have my DV form, please? And you understand that, sir?
Yes.
And what I mean by no contact is I mean that you are not to attempt to have contact with her directly or indirectly, either or through yourself or with other person's participation. You are not to contact her by electronic communication. That is included in that is you are not to, including but not limited to, by phone, email, texting, internet, social media, and you are not to mention her at all online. I will also indicate that you are not to go to the address of 3239 East Michigan Avenue in Ypsilanti Township. I will order that if the defendant does post bond and if he is released, that he is to be placed on a GPS location tracking tether with the exclusion zone. Do you understand all of those terms, sir?
Yes, sir.
All right. Is there anything further from either side?
No, Your Honor.
Thank you. Thank you on that case. I will also indicate, Mr. Williams, that you are also before the court on a charge on a failure to appear, this being case 252-0702, on a failure to appear at is this a show cause?
It's a pretrial.
At a pretrial. I will cancel the warrant in that case. I will set your bond on that case at a $5,000 10% bond. I'll reset the pretrial for
April 15th at 8:30.
April 15th, 2026, 8:30 before Judge Barr. Then on the case 25F2-0428. This is for a show cause. All right. In this case, you failed to appear for a show cause hearing regarding the payment of fines and costs. I will cancel that warrant at this time. I will set your bond at an amount of $7,500. I'll give a 10% privilege on that. I will reset the show cause in this case too.
April 9th at 9 a.m.
April 9th, 2026, 9 a.m.
Yes.
9 a.m. before Judge Barr. Right? Thank you. Court does call the case. Is this my, oh, that's my cheap room. Lori Anderson versus Armani Lyman.
Good afternoon, Your Honor. Christopher Wilby Wednesday. Verbal.
Your name?
Hermione Langford.
All right. Okay, folks, where are we on this case? What is plaintiff's claim this time?
I just wanted to let you know that I didn't get the whole 2,500 in, but
See that.
1,000. I will have the rest of that next Friday to turn in. I also would like to countersuit just because I came here, I'm still not peacefully.
Well, you needed to file something with the court before now. What is your claim in this case?
Your Honor. Claim title $11,707. I'm sorry. And that's inclusive of court costs.
How much is that?
And Your Honor, if you can't sense, this is a case that maybe the parties could be working together, and there's some issues on the side. The defendant's statements that they wish to file additional claims. We would be requesting a judgment by no tribal issue today. However, I would not be opposed to an adjournment, considering I'm a covering attorney and Mr. Jarbo may be more familiar specifically with what's going on with the parties. I don't want to.
Right. Well, I am inclined, the total amount that's owed is, I'm sorry, what was that total amount again?
$1,707.37.
I had, how much were your court costs, counsel? See if because what I have is at the last hearing, March 13th, it was $11,529.39. And I don't know why that number would have gone up.
The amount that it's gone up would be the $178 in costs.
What is it? Okay, gotcha. All right. Anything else from either side?
I believe my client may be trying to make a statement and she wants to.
I have a inspection scheduled for April 6th with the Pittsville Township. And I need to have access to the property and make repairs for their certificate of completion.
You're going to need to work. I understand that, but you're going to need to work that out, comply with the local ordinance regarding notice. I'm not going to get involved between the two of you trying to get into the property. You guys are going to have to figure out a way to work that out.
I filed a 7-day notice. I will submit it to the court on Monday, but I can't.
7-day notice for what?
There's some things I need to clarify off the record, Your Honor, and you will go over those procedures. Thank you.
All right. So you deposited into escrow $7,600. When are you going to have that other balance? Because you were supposed to deposit $2,500 in, and then I might consider something else, but you didn't do that.
Yes, I came up short. I will have the rest of that next Friday.
Court's going to find no tribal issue. I'm going to grant a judgment for possession in the amount of inclusive court costs of $11,707.37. With a writ to issue, you've got to have all of that, the difference paid by March 6th. And I'm sorry, April 6th. That's a 10-day period, 2026.
How much again? I'm sorry.
Well, you can give me 11,707.37 minus 7,600.
$4,137.37.
Got to have that paid by the 6th.
I thought it was.
I'm sorry? I'm sorry?
I thought it would have just been the $2,761.60.
No, I'm gonna give them, you were supposed to bring 2,500 in. I was very careful with you to get that in. That didn't even include the full amount to bring that up. I'm not gonna hear a dispute where you were supposed to pay something, you haven't paid it to the court. I'm granting them a judgment. I really don't have a tribal issue in terms of this judgment. I'm gonna grant them a judgment. That balance, I'm gonna release the escrow to the plaintiff. And the balance has to be paid by the 6th. In terms of any inspection or whatever, or however you guys want to do, you guys figure. Thank you.